All right. Well, hey, we're looking at about 11:31, so it's time to get going. First and foremost, good morning, Texas. I hope y'all are doing well in summer heat so far. We've gotten a lot of rain. I think I was reading an article the other day. I think every lake in Texas is full except for the hill country lakes and a few valley lakes. So, not great for me living in the hill country, but I know elsewhere in Texas we've gotten a whole lot of rain, which has been good and much needed. Unfortunately, it's brought a little bit of humidity to the rest of Texas. You know, Houston and Dallas, y'all may be used to it, but hey, Austin's not. We don't like that humidity quite as much, but we'll take it if it raises our lake levels a little bit. So, anyways, welcome. Glad everyone's here today. Today we're going to be talking about a subject that is near, I don't know if I'd say dear, but it is near to my heart. I'm involved significantly in the legislature and have been for a number of years. And we're going to talk a little bit about the POA industry and how it has responded to basically a much more active legislature over the past 15 years, right? It all kind of started in 2011 and it really started building up. So we're not going to talk about the filing process. That'll be another presentation when we get closer to our 2025 legislative session. But we're going to talk specifics. So first and foremost, got to give that attorney disclaimer. So again, the information presented today is based on the law as it exists today, June 26, 2024. The law can change. Court opinions can come out finding something constitutional, unconstitutional. So keep that in mind. And then finally, the information presented is for educational purposes only and does not constitute legal advice. If you need that legal advice, please reach out to your management company. They may be able to help. And if they can't, reach out to your attorney, your legal counsel for the association. She, or they should be able to help. With that, let's dive right in. So our agenda today, again, we're going to be talking about bills that have passed over the past few legislative sessions. I think we're going to go back to 2019, any further back, and it just we'd be here for hours and hours. We're going to talk about some of the effects of the bills that passed, actions that your POA, and a quick sidebar, POA is a legal term of art that includes both single-family community associations as well as condominium associations. So when I use the word POA, I'm referring to both condos and single family. I'm going to do my best to carve out the laws that passed so that you know whether or not it applies to only condos, only single family, or both. And then we're going to talk about kind of the crystal ball, seeing if we can predict what kind of bills we're going to see for this next legislative session. Okay, so the first bill, this is a funny bill. I've got a quick sidebar story I'll tell on it once I get through it. This was back in the 2019 legislative session. This is the lemonade bill. And it really adds a section in Chapter 202 that applies to both condominiums and single-family communities, so POAs, 202.020, and it basically says we cannot prohibit, regulate, or require a permit or fee for the occasional sale of lemonade or other non-alcoholic beverages. You've got to, there's a good argument you've got to get permission of a property owner, but if it's common area, the association may not be able to regulate overly much for those lemonade stands within the common area. It does limit our responsibility and liability as it relates to those stands, but a quick sidebar on this. So I was down at the Capitol when this bill was in front of a committee. I'm, suited up, about to state my case why this lemonade bill was a bad thing. And before I went up to kind of provide a little POA background, we had, I think it was like 4 or 5 little kids, Boy Scouts, Girl Scouts, and they are all suited up as cute as can be, talking about how wonderful this lemonade bill is going to be for them. And you have, I think it was this, yeah, it was the House committee, and they all get their cell phones out and start taking pictures. They get down and take selfies, and I'm just like, this is not going to go well for me. Arguing against little kids and lemonade. Regardless, as you can imagine, that bill passed. In terms of how it's affected communities, it really hasn't. I think since 2019, I've maybe had one or two cases where I've had to navigate through the process and apply the statute, but it just didn't seem like it was that big of an impact for at least the communities our law firm represents. So anyway, funny bill. Next one. This was a big bill, a very, very, very big bill. Not as big as Chapter 209 of the Texas Property Code, which kind of came into being back in 2011. But Senate Bill 1588 was still a very large bill, and it brought a lot of changes to community associations in Texas, and we're still dealing with it, and we're still dealing with the fallout because a lot of self-managed community associations may not even know about this law change, which can be a little scary. It means they may very well they're likely not complying. So, anyways, let's dig into the Senate Bill 1588. Okay, the first section dealt with collections of assessments, and it basically says, hey, you can't collect an assessment if your deed restrictions are not filed in the real property records. This one really wasn't that big of a deal because we already had 202 that said, hey, look, in order to be enforceable, it's got to be recorded. Developers always record assessment lien rights. So again, not too big of a change. Religious displays. This one was a very big one. And so prior to this law change, the religious display was limited to a certain size. And as long as the display was within that size, they could put it on their front door. This law changed it so that there are no size limitations, no materials. It can't be offensive or attached to certain easement areas or other improvements. But other than that, it allows for an owner to install whatever they want within their property as long as it doesn't violate easement or is patently offensive to a passerby. So it really allows now for owners to install whatever type of religious display they want, generally speaking, with no size limit, no time duration limit. So we have seen some of this. We definitely have seen some issues where owners are installing these massive animals in their front yard and trying to link it up to a religion. And sometimes, they can show that it is a sincerely held religious belief, and other times they can't. We've got to push back on it. So we have seen some ramifications with this. We've heard from different communities that it has negatively impacted marketability of the community. We're dealing with one right now where we've got one of those 15-foot skeletons. Y'all probably know about those for Halloween, right? Home Depot, big deal. It sells out all the time. And we've got somebody who's trying to dress up this 15-foot skeleton for the different seasons and has been trying to link it up to it being religious. So we've been having to fight that and a couple other ones. So that one's definitely had some effect on us. Swimming pool fences, again, not that big of a problem, right? State law requires swimming pools to be enclosed properly. This basically allows for certain types of fencing, and we can't restrict that. And again, communities we represented, we really never ran into that issue too much. All right, security measures. This one was a big one. It really only applies to single family communities, and it basically allows for an owner to install security measures, and it gives different examples. But one of those examples is a perimeter fence. A perimeter fence. Perimeter basically means the perimeter of an owner's lot. And so if you've got a community as it stands today that is a no fence forward of the front residential structure, right? You can't have a fence in the front yard in a nutshell. And we've got one of those communities. This would allow for an owner within that community to completely enclose their front yard, right? So they get fencing in their front yard and their backyard, as long as it is determined to be a security measure. The one thing associations can do, and the law says this, we get to regulate the type of fencing. So there are security measure policies that you need to adopt to be able to regulate that security measure fencing. There's other security measures that owners can install as well. The burglar bars, that's one item we've had to deal with. Very bright lighting, that's another item we've had to deal with and push back because, on sometimes that bright burglar lighting, what happens if it's invading the privacy and property rights of a neighbor? Does that mean we get to restrict it? So all things associations are having to grapple with as it relates to security measures. And it was a teeny tiny bill. It was only a couple sentences long, but those couple sentences really had a big effect on community associations. Next one, resale certificates. This only applies to single family communities. It caps resale fees at $375, updated fees at $75. And then it reduced the second request delivery from 7 days down to 5 days. This doesn't affect community associations directly quite as much, but it did affect a lot of management companies because it's the management company, if you are managed, that provides this resale certificate service, right? So they had to move their fees around a little bit, ensure they were compliant with that cap. And just a quick sidebar on resale certificates. It's basically linked to the sale of a home, right? So seller is selling, enter into a contract with a purchaser, title company gets involved. One of the things the title company requests from the management company is a resale certificate. And that, gives the governing documents, talks about deed restriction violations on the property, how much is due and owing, what's the assessment, all that kind of stuff. And then the title company takes that certificate and incorporates it into the closing and provides a copy of it to the seller and the purchaser. Just a quick sidebar. 207.006 Texas Property Code got updated, and it requires associations to make current versions of their dedicatory instruments available on an internet website maintained by the association or management company. So you've got to get all your stuff up on your website and available to association members. It only applies to communities composed of at least 60 lots or an association that is contracted with a management company. Next one, Section 10, TREC filings. This one's no fun. What this does, it's the Texas Real Estate Commission is what TREC stands for. It's kind of the real estate arm. It's a governmental entity. TREC, Texas Real Estate Commission, and it basically says, hey, look, you've got to file your management certificate not only in the county records, but also with TREC. And what is a management certificate? It now, as a result of this law change, and this is only single family, I want to preface that, you've got to include kind of all the declarations and all the amendments to the declarations, and you've got to include a fee schedule. Hey, what fees is the association charging associated with a closing? What are the fees? You've got to lay them out, period, end of sentence. It's got to be in the management certificate. And then once that's filed with the county, you then have to file it with TREC, Texas Real Estate Commission. So it's a double filing requirement. You've got to add all your fees in there that you're charging. What is that? A capital improvement fee, right? So if an owner buys and they have to throw in a one-time fee, you've got to include that on the management certificate. Resale certificate fee, re-ups on that resale certificate fee. Maybe the management company charges some sort of transfer fee. You've got to list that as well. So all that has to be on the management certificate. And here's the scary part. Here are the teeth. If you fail to properly have a management cert or have it filed in the county or with TREC, the owner that is kind of involved in this issue, maybe they're delinquent, they're not liable for attorney's fees incurred for collection of assessments during the period that you are non-compliant with this new 2020 requirement. I've dealt with this a few times. It's kind of one of those gotchas where you're like, well, you didn't comply with the new law. So keep that in mind. There are some teeth associated with this new law. All right, ACC members, this one, far-reaching consequences. We're dealing with it every single day. It basically requires that an ACC member not be a current board member, a current board member's spouse, or a person residing in a current board member's household, period. End of sentence. It definitely has some, it's got some noticing requirements as well. When the ACC denies a request, they've got to describe with particularity the reason for the denial and also let them know that they are entitled to a hearing before the board within 30 days of the date of the denial, and then you've got to have the hearing within 30 days of the owner's request for the hearing. So it's before the board, and then the code does say that the board's got the authority to overturn a decision of the ACC as well. And one caveat here, it only applies to community associations that consist of more than 40 lots, and it's only single family. Board meetings, it ups, and again, single family, not condo, it ups your notice requirement for regular board meeting from 72 hours to 144 hour, unless you're doing a special meeting of the board. Special meaning there's got to be a special reason to have it. If it's a special meeting, it stays at 72. All right, next up, contracting for services. Again, single family, and it applies to contracts costing more than $50,000. If the contract costs more than $50,000, you must have a bid solicitation process that the board files, right, or follows. So you need to have at least 2 to 3 bids. I like 3. 3 is a good number. But for contracts that are more than 50,000, you've got to have a bid. You should have a bid solicitation policy in place so the board knows what they need to do. And this one, in terms of ramifications, it's just gotten complicated because what happens if you're in a contract with a contractor that renews? It's like an evergreen contract. Do you have to get a new contract every time it evergreens, every time it renews? And your counsel or your management company is going to have to look at the terms of the contract to determine whether or not this new $50,000 requirement applies. Well, what happens if the contract is kind of like an at-will contract, but it costs more than $50,000? Do you only have to do it once, and then after that time, because it's at will, you're good to go? All good questions, and getting with your manager or your counsel is going to help answer that. But again, get that bid solicitation policy in place. And then credit reporting now for y'all, for those communities that credit report, basically report to a credit bureau, you have more noticing requirements. Our law firm really doesn't engage in that much. We just don't. Anyways, there are some management companies that do, and if they do, they've got a lot more legal requirements to follow before they can credit report. Man, we're still on 1588. I told you this was a big one. 209 hearings, now you've got to give like an owner a packet. So a 209 hearing is, so we've got an ACC appeal hearing, right? ACC denies, you get to appeal to the board. We also have a violation hearing right. So an owner violates your deed restrictions. Well, when you send what's called the 209 demand letter, it's a certified letter, you've got to give that owner a right to a hearing. And that's always been the case, even before 2021 law change. But what they did do is they are now requiring this little evidence packet that you've got to give the owner, and you've got to give it within that 10 days prior to hearing. And if they don't get it, then they automatically get a 15-day postponement. And it's not that big of a deal. The hearing packet is typically pictures of the violation and then the letters that the association sent to the owner. So not that big of a deal, but still something new that management companies need to be aware of. It's only for single family communities. Another interesting one is this JP court jurisdiction. Now if an owner believes Chapter 209 was violated, they can file a claim in small claims court, JP court jurisdiction, basically. And the funny thing on that one is, well, they already had that right to file a lawsuit, whether it be in JP or district court. But this kind of makes it clear, hey, you can file something. All right, still in 2021, security measures. This was kind of a bill that tracked 1588, so we're going to keep going past that one. This one applies to condos. Hey, condos, for those of you listening, y'all, your ears need to perk up now. As of 2021, you are legally required to adopt an open records policy and a records retention policy. This applies to all condominium types, whether you're what's called a pre-TUCA condo or a TUCA condo. Quick sidebar. What does that mean? TUCA stands for the Texas Uniform Condominium Act. Chapter 82 of the Texas Property Code. That's what TUCA is. And the law says this: if your declaration was filed before January 1st of 1994, you are only subject to certain parts of TUCA. If, however, your condominium declaration was recorded on or after January 1st of 1994, all aspects of TUCA apply to you. Now, there's other ways for pre-TUCA condos to get subject to TUCA in full. I'm not going to go into those, but that's the general rule of thumb. This applies across the board, and it requires you to have that open records policy and a records retention policy. Single family has had this requirement for years and years. It just got borrowed and placed into the condominium books, and it fairly tracks the 209 law. So you're legally required to have this. What happens if you don't? Here's the thing that really should encourage y'all to get this done if you haven't. If an owner makes an open records request properly, certified mail in writing to the management company, and you don't have an open records policy in place, the cost for all that work you put in to respond to that request, 100% of it gets borne by the association. Period. End of sentence. No ifs, ands, or buts about it. So if an owner makes a 5,000 page request that's going to take your manager 20 hours to put together, you foot 100% of the bill. Now, if you have an open records policy in place, you get to fee shift. You get to fee shift those fees over to the owner and make them pay before you do the work. Now, the fees you get to charge are going to be much less than what a manager and management company is going to charge, just because it is what it is. So the association still has to cover that delta, but it's still really nice when you get that 5,000 page request, you can fee shift back to the owner and say, look, we're happy to do the work, but here's what you need to pay us before we do. So keep that in mind, condos. All right, fines. This was a big one. 2023 legislative session only applies to single family. You have to update your fine policy. Period. End of sentence. Now, this only applies to single family, number one. And number two, it only applies to those single family communities that have fining authority. So your declaration or your bylaws need to have some authority for the association to fine. Except I think there may be some limits for Chapter 204 communities in the Houston area. But general rule of thumb, it must be in your documents, in your declaration or bylaws. You also have to have a very specific schedule of fines. And now, once the fine policy gets recorded in the real property records, you must, this is not a may, this is a must, you must post the recorded fine policy on a website that is publicly accessible. What does that mean? That means non-owners have to be able to access the fine policy. That doesn't apply to other recorded documents, but it does apply to fine policies for single family communities. The law is very, very clear in that regard. So make sure your recorded fine policy is publicly accessible. So it's accessible to me. For instance, I'm not your attorney. I should be able to find your fine policy by going to a website and finding it that way. And county records don't count. It's got to be a website maintained by the association or its management company. County is not maintained by the association or management company. So I keep running into that issue, which is why I'm kind of harping on it. I'm sorry. So keep that in mind for your fine policy. Assessment liens, for those of you that file liens, you now have additional notice requirements and essentially a 120-day waiting period. Many communities have already got a process in place where they're likely going to meet these new lien requirements, but just know that there are more requirements now. So before your council files that lien, and council attorneys have to file a lien, non-attorneys can't under Texas law. But before your attorney, files that lien, I would just, double check with him, her, or they that you're compliant with the new law. They should know, as long as they're kept abreast of all the legal changes, but just keep that in mind. And I promise I'm going to try to cruise through this as quickly as I can, because I know there's going to be a lot of questions on what's passed and what's coming up. Okay. Other bills that we've seen through the years. And again, we're really just going back to 2019. Rewrite of TUCA, the Texas Uniform Condominium Act. And we try to prevent that because TUCA is what's called a uniform code. That means that it is similar in nature and scope to other codes across the country. And if you change TUCA too much, it loses its uniform nature. Uniform codes tend to be a little stronger in terms of courts. You have a little more oomph in a uniform code than you do a non-uniform code. So we try to avoid changes to TUCA where we can. Board member recall procedures. We saw that in 2021 and 2023. I actually spoke on that in 2023 to try to kill it at committee level by saying, look, there's already a board removal process in associations bylaws and in state law. Chapter 22 of the Texas Business Organizations Code already speaks to that statutorily. And so we were able to effectively defeat that one back in 2023. I got to speak at I can't remember if it was the House or Senate. Anyways, very interesting. JP court suits against board members, that was defeated, but it was introduced in 2021 and 23. Street parking, we weren't necessarily opposed to this because it was kind of limited to emergency vehicles. So we want to support our emergency vehicles where we can. So there was some street parking stuff, and we had, back and forth on proposed wording. Wind turbines in 2023. This was crazy. It would have allowed for wind turbines throughout all residential communities. I think it may have applied in limited scope to condominiums potentially, but it just would have really caused a lot of headaches. And when you look at the data behind wind turbines, they don't generate that much power unless you get them very, very big. Some of the bills that were introduced on wind turbines didn't even have size limitations. And then, of course, y'all probably hear about this all the time. Chickens, rabbits, bees, all kinds of fun stuff. We saw it 17, 19, 21, 23. We'll see it again in 25. There's no doubt in my mind. But as the law stands today, I'm going to do a quick sidebar here. If a deed restricted community says no chickens, it is no chickens, period, end of sentence. And that kind of ties into what's called the Right to Farm Act and the Right to Farm Constitutional Amendment. There was an amendment that passed, so it's in our Constitution, that basically says, hey, an owner has the right to farm. And and raise livestock, plant stuff, et cetera, et cetera. And does that mean that we can no longer restrict chickens or cows or a massive vegetable garden in our front yard? And the answer is no. We can still regulate that. Absolutely. As long as it is in our deed restrictions. And why? It's in the Constitution. Why can we still enforce? And it's the idea that the Constitution doesn't prohibit or prevent a person's right to private contract, a right to contract. And that is what deed restrictions are. They are contracts. And so when an owner buys into a community, they are basically entering into a contract with their neighbors and with the association where they are agreeing to give up certain sticks in their bundle of property rights. One of those sticks is your chicken stick. You're giving it away if you're in a no chicken community. And so I've had to speak with various news sources over the past probably 9 months to explain that idea. So again, when you hear that constitutional amendment buzz, just know that you can push back if you've got deed restrictions preventing whatever it is. And look, big picture, if you've got a community that wants chickens, that's fine. Amend your declaration. I just got done doing an amendment for a community that really wanted chickens. And so we did an amendment to declaration and it passed, and they've got regulations in place. So again, it's not that I'm opposed to chickens. I live out in the country. I'd love to have some chickens. But it just needs to be done the right way, and we need to give the owners their voice and let them decide what they want. Senate Bill 1688 was a bill in 2023 that TLAC, the Texas Legislative Action Committee, really pushed hard. We worked with the realtors on this. It would have done a number of things, but a couple of them were it would have done a fee cap for resale certificates for condominiums. And again, that was the give we had to give to get what we wanted in return. And the wants we wanted, number one, for single family, it would have allowed the board to serve on the ACC. It would have resolved that issue because I probably once or twice a month, we run into this problem where I've got a board that can't get ACC members because it's just so hard to get those volunteers. And this bill, had it passed, would have allowed for you basically send a call to arms to the community, and if nobody responds, then the board can serve on the ACC for the next term. It would have also allowed for us to regulate security fencing in front yards as long as our deed restrictions said no fencing in front yards. So it was a good bill. It passed the House. It passed the Senate. It made it to the governor's desk, and the governor vetoed it because of the drama that he was having with, I believe it was the Senate. And because of that, because it was a Senate bill, he vetoed it. It stinks. It had nothing to do with our bill, but it got vetoed, and we were never able to get it passed. So we will likely see some form of that bill in the 2025 legislative session. So again, we've got to draft policies to interpret the law. It is so important to get those policies in place, especially if the law now conflicts with your declaration. For instance, I'm just going to give you an easy example. Let's assume your declaration, you're a 90s community, and your declaration says no solar panels on the roof, right? It says that, single family. And we had a law change that says solar panels are legally allowed. I think it was 2011, and then there was a 2013 change and a 2015 change. Regardless, solar panels are now allowed. But if this board, let's assume we didn't have a management company, the board doesn't know about this law change, right? And they restrict somebody and say no, you cannot have a solar panel on your roof. Well, now we've just made a decision that violates state law. That's why it's so important to adopt that policy. And the policy basically says, hey, look, we know the declaration says no solar panels, but state law trumps, and we're going to comply with state law. So here's the new rule. It allows the board to better function, allows your management team to function better as well. That's why policies are so very, very important. Again, since 2021, I've had a lot of my communities adopt as many as 10 policies, having to adopt that many policies. So again, if you have not adopted these new laws since 2021, I really recommend you look into that. Get with your manager, get with your council, and figure out what you need to do to be compliant. Condominiums, not as many. Condominiums, I think since 2021, you've just got two or three that you need to adopt. Unfortunately, look, this is what we've got to deal with. It inflates governing documents, right? It makes them more robust, but it is what it is. And it can add confusion if, especially if you are not adopting a policy. So again, very important for you to adopt those policies. Volunteer issues. Look, these laws have really affected volunteerism. There's a new law. I'll quickly do a sidebar on. This is a state law presentation, but I'm going to talk about a federal law. Y'all have probably heard this word before. The CTA stands for the Corporate Transparency Act. It applies to all community associations across the country. So it applies to Texas. Doesn't matter if you're a condo or a single family community. It does not apply to civic associations. So those associations where there's no assessment obligation, where you really don't have a formed entity, it doesn't apply to you, which, if you're on the phone, that's good news. But otherwise, it applies to you. Single family communities, condominium communities. The other one it doesn't apply to are 501c4 corporations that are some very large single family communities that are what are called a 501c4 corporation. They don't pay sales tax, basically. You don't pay sales tax. And for those communities, you don't have to comply with the CTA. Everyone else does, which is the vast majority. I would say north of 90% of community associations across Texas have to comply. And you've got to give certain information to the federal government regarding who's on the board and their background, their mailing address, a copy of their ID and or passport. And if you don't, there are significant penalties, both civil and criminal penalties. So please get with your management company to figure out the best way to attack that and comply. We are recommending for management companies to do this. We're offering this as a service, but we're just not the best placed, person to help, third party to help. Why? We're your law firm. We don't know when a board member resigns or when there's a new election. We don't always know that, right? The manager typically does always know that. And if you are self-managed, get with your counsel. He, she, or they should be able to guide you in how to comply, and they may be offering that service to you to get you going, to get you up and running. So keep that in mind. A lot of these changes, not all of them are negative. We've definitely got some positive stuff. There was a bill that passed in 2023 that basically says, look, associations can't regulate method of payment for a landlord-tenant relationship. I think that's a good thing. We don't want to be involved in how a tenant pays their landlord. We do not want to be involved in that. So that was a good bill. There was another bill regarding insurance and areas that are affected with hurricanes and flooding and that kind of stuff. There's some insurance protections now if you're having trouble getting insurance. And again, as I kind of hinted on earlier, I'm a member of TLAC, the Texas Legislative Action Committee, and it's a committee that was formed last session, actually in 2022, and it was formed to represent community associations across the state and to work with a lobby group. We've hired a lobby group that lobbies on our behalf. It gets us in the door. It allows me to go and speak to senators and representatives, and y'all too. Here's the exciting thing. Every year we have what's called a rally day, where we have managers, vendors, and community association volunteers, board members, ACC members, come down to the Capitol and speak with their senator or their representative. We do our best to tie you to your senator and your representative so that you can talk about your community association and why something is a good thing or a bad thing in terms of the bills. And our date's been locked in. It's March 5th of 2025. So, it's a little far away, but it'll come quickly. So I really, if y'all haven't already, it would be awesome. It'd be great to see you down at Rally Day. It's a lot of fun. Type in Texas Legislative Action Committee, and there's a website that gives you information on on how to get involved. Now, here's what I've seen, because session's coming up. Again, lots of requests to explain the constitutional amendment, that right to farm. So I've been involved in that. We also had a community association up in the Dallas area that tried to initiate an outright ban on leasing. So no leasing, period. That's a concern for TLAC. There may be some issues with constitutionality of that. So we're having to scramble with that right now. But I'll reiterate this, and this is a hard term to define. I was joking with somebody, a TLAC member yesterday. He made the joke on this. Be reasonable in your enforcement. Be reasonable in your rules adoption. If you don't know what reasonable is, get with your management company, get with your council so that you can design things that make sense. Number one. Number two, as it relates to enforcement and collections, be consistent with enforcement, be consistent with collections. Do not pick and choose what you want to enforce. Do your best to enforce everything so that you avoid that arbitrary, capricious, or discriminatory argument. Hey, you're picking on me because XYZ. So try to avoid that to the best of your ability. And finally, if y'all are interested in contributing, please, please, please reach out. Texas Legislative Action Committee is a great resource, and it is made up of nothing but volunteers, other than our lobby group that we pay, right? That's the one group we pay money to help lobby and represent community associations. And keep in mind, it's not that we're against something or for something necessarily. We are for allowing owners to self-regulate. If owners want chickens, let them have chickens. Let's just do it the right way and amend our declaration. So again, advocacy efforts, interact with your House members, your senators. We always try to avoid ambiguous legislative action. So if a bill comes across our desk, and I'm a co-chair on the bill review committee, so we look at all the bills that come in during legislative session. We look at it for what it does, number one, and then number two, how ambiguous or objective is it? Is it very easy to understand and interpret, or is it very ambiguous or hard? If it's the latter, then we either want to strike it completely or amend the wording to make it more objective. And again, we try to explain this, but associations are nonprofits, right? So we have all these new requirements that cost money. Who ultimately pays? Homeowners, right? Homeowners ultimately pay because it just trickles down, because we're dealing with nonprofit corporations. The money that goes in is the money that goes out. So again, that Senate Bill 1688 that failed on the governor's desk, you're likely going to see that again next year. And legislature continues to remain active. Fortunately, we weren't in the crosshairs of any interim charges. So there's these charges that the legislature issues during even numbered years, right, non-legislative years, where they want the certain committee to look into an issue, and sometimes the POA is within those interim charges. This year's interim charges, we were not in it at all. Secondarily, we may have been in insurance and leasing and property rights purchases, all those limitations they were looking at, but nothing directly. And again, look, we're POAs. Everybody loves us, right? No, they don't. So we tend to see legislation that affects community associations every legislative session. So we'll likely see something. And as time progresses, our law firm gives regular updates on the bills that are out there, and Texas Legislative Action Committee does as well. We are going to continue giving y'all legislative updates, and as we get closer and closer, we're going to do a legislative 101 to talk about what kind of the bill going through the process. And we have got 15 minutes, which is great. Let's get into questions. I know there have been a lot that have been submitted throughout our presentation. So let's go through. Yep, I covered the Corporate Transparency Act. Again, I could spend an hour on the Corporate Transparency Act, so I only spent a couple minutes. We've got a great we have a great presentation on the Corporate Transparency Act that I did a few months back. It's actually on our website and on YouTube. So if you're interested in that, you can watch it. It is about an hour long. Time frame for responding to the original resale certificate, I believe it is 10 days. Give me a minute. I'll give you a specific reference. Sorry, hang on a minute. 10 business days. So 10 business days. Is the association allowed to establish their own fees for resale certificates in addition to the management companies? So a resale certificate fee requires that you do something, right? So if the association is not doing anything, if the management company is doing all the work, there's no authority to charge a fee, right? A resale certificate fee. Now, if the association is doing all the work on the resale certificate, well, then the association can charge it, but typically it's the management company that does that. Now, other fees that an association may charge, not the management, but management collects it on your behalf, conveyance fees and working capital fees, that kind of stuff. And that's going to be located in your declaration, in your deed restrictions. But if you're not doing the work, you typically cannot collect the resale certificate fee. Are they allowed to request a quote? I mean, if there's an owner that's delinquent and they're entitled to a statement of account, but they don't get anything else unless they request a resale certificate and pay the fee. So they don't, it's very hard for them to get around it. And title companies, any title company worth their salt in Texas is going to say, no, you need a resale certificate, period, end of sentence, because they want to reduce their liability as a title company as much as possible. And a resale certificate kind of helps do that. Do you have to add late fee schedule for and fine schedule for violations on? No. So the management certificate, the question is, do you have to add late fee schedules and fine schedules on a management certificate? And the answer is no, you do not. You do not have to add that. Let's see here. I'm going to give you the exact language that you've got to include. Give me a second here. See, it is, you have to give the amount and description of a fee or fees charged by the association relating to a property transfer. So again, the only fees you include in the management certificate are fees related to the transfer. So transfer fee, resale certificate fee, capitalization fee, right? There's a fee you pay upon sale, working capital fee, all those things. That's where you add it. Are ARC denial hearings required for developer controlled properties? No, that does not. So it's 209.00505, and it does not apply to, number one, developer period associations. And then number two, for a community that is less than, or 40 lots or less. So those requirements don't apply if you're a small community, 40 lots or less, or you're within the developer control period or declarant control period as defined under 209. What are the options available to property owners if the POA is not getting multiple bids? Again, I can't give legal advice, but get with your management company. Let them know, point the law out, and hopefully that management company gets with counsel quickly so that can be looked at and any issues can be remedied so that your community is complying with the law. There needs to be a way to file a notice to release the management company in the event of termination. That's more contractual law, right, between the management company and the association. It's typically not statutory. So the management agreement will control there. And if there needs to be some sort of release, then that can be contracted for. I'll say this, even if you get a release, you're going to be subject to liability down the road for the stuff you did while you were the management company, right? I mean, it is what it is. What are the consequences for failure to adopt and record a fine policy and schedules? So again, not trying to get legal advice, but the law is you have to have a proper fine policy in order to fine. So make sure you have that in place. I believe that took effect January 1st of this year. What do we do if the association does not have a website? Well, if you don't have a website, that's okay. But if you're managed by a management company, I think you've got to get one in place. Let's see here. I'm going to go back into 207 to give you specifics. See, all these laws, you've just got to look it up here. A POA to which this section applies in 207, single family, shall make all of your documents available on a website maintained by the association or a management company on behalf of the association and available. It says you shall make it available. And it only applies to a community composed of at least 60 lots. So you've got to have at least 60 lots. If you do, you've got to comply. You have to have a website. So they're fairly cheap. What's that? There's a great little website maker. I can't remember it. I'm sorry, but it's fairly cheap to get a website going. How specific does the fine policy need to be? Again, it says a schedule of fines. What does that mean? Get with your counsel. He, she, or they is going to give some advice. Our advice is if it complies with 209 on fine schedule, curable versus uncurable, very specific to schedules, and threat to health or safety. That looks like a schedule of fines to me. How do we get a fine policy added when we can't get the 67% to adopt it? So your bylaws, maybe the board can amend its bylaws to add fining authority that may be allowed without an owner vote pursuant to 22.102 of the Texas Business Organizations Code. Using may a lot in that answer because, again, an attorney's got to look at it and analyze the statute to see whether or not it applies to your community. If current governing documents do not include the ability to fine, is it as simple as the board amending the bylaws? Again, maybe. It may require an amendment of the declaration, which goes back to that 67% of all owners that Erica mentioned, that you need 67% of all owners to approve an amendment to the declaration. That's the general rule for single family communities. And again, we're just talking single family here. We're not talking condo. Just to confirm, only an attorney can file a lien. Yes, that is Texas law. It is a document affecting title to property. It places a cloud on title, and so there's statutes that basically say it's a legal document, which means an attorney has to do it. Repeat street parking information. Okay, so that bill was introduced in 2023. It's not the law. I want to make that clear. It was just a bill, not the law. It would have allowed for emergency vehicles to park on the street in certain circumstances. So again, didn't pass. Next one, but chickens and bunnies, etc., who are documented as support animals, doesn't state and federal law allow them? Very good point. Yes, maybe, right? The attorney answer, maybe. If a chicken or a bunny is a proper emotional support animal, or ESA, then yes, they may be able to have a few chickens. I think we had one where we had to fight where there was somebody with 10 chickens, and ultimately it was determined that they didn't get to have 10 ESAs. Well, I like Bob and Bill and Sue. Bob really soothes me at night. Bill soothes me in the morning. Susan just likes to hang out with me. And they were trying to prove up these 10 chickens each gave ESA support. And I think we were able to ultimately get it down to like 4 or 3 chickens. But again, general rule of thumb, yeah, ESA stuff, press pause and get with your manager, who will likely require you to get with your counsel because that federal and state law is tricky and you want to make sure you navigate it properly. 209 hearing requirements. Does the violation letter sent with the pictures count for the packet? No, it does not. You need to give a separate packet at least 10 days prior to the hearing. Very good question. If the U.S. Constitution allows for right to private contracts, wouldn't that also apply to rules about political signs? Declaration says no signs whatsoever except a single for sale sign. So I'm going to press pause there. There's already a political sign law in place in the state of Texas. Chapter 259 of the Texas Elections Code. Chapter 259 Texas Elections Code talks about political sign rights for community owners in associations. So you already have that right, and it is a state law. What are recommended guidelines for changing policies? Boy, that's a loaded question, isn't it? Very good. Unfortunately, I don't have an answer. It really depends. Darn attorneys, given the it depends answer. I apologize for that. So get with your counsel, because sometimes you can adopt guidelines. And the general rule is this: a guideline or a rule, assuming you've got rulemaking authority, that merely interprets your deed restrictions is okay. A guideline or rule that creates completely and utterly new rules, regulations may not be okay. It really depends on whether state law says you can adopt that crazy new rule reg. So you've got to think about that when you're adopting rules and regulations. You can clarify but not create new deed restrictions. General rule, again, multiple exceptions to that, but hopefully that helps a little bit. Man, we are just cruising with these questions, which is great. Aren't there significant penalties for not doing CTA correctly? Yes, there are significant penalties. Fortunately, doing CTA correctly is very, very easy to do. It took me 5 minutes to get my FinCEN number. So and that's the number, a special number you get when you do your stuff. So 5 minutes. And what about liability for the management company? Again, not counsel for management companies, but many times it's a good idea to establish an agreement between the management company and the board, establishing roles and responsibilities, right? Again, management companies are going to be best suited to do this because y'all are involved in the day-to-day affairs. Finally, and one thing I like communities to think about with the CTA is you really need to seriously consider adopting an amendment to the bylaws that basically says this: hey, board member, if you don't give us the information required by the CTA within a date certain, you're automatically removed from the board. Because, to Brian's point, you want to avoid liability for the board members individually, liability for the association, and potential liability for the management company. So try to get a bylaw amendment in place that allows for automatic removal when a board member does not comply with a federally mandated requirement, right? It's a big deal. And the penalties are very, very, very hefty. I don't like how hefty they are, but it is what it is. Solar panels. Solar panels are POA subdivision is responsible for painting and maintaining exteriors and roofs. Solar panels are prohibited because of the maintenance requirements. And I think you are good to go there. Very good question. And the law says, look, if you're responsible for maintaining something that an owner wants to put a solar panel on top of, you do have the right to say no, because you've got that maintenance responsibility. And if they basically install a solar panel, your maintenance responsibility would go from 1x to maybe 3x because of all the additional stuff you have to do to avoid those solar panels. So very good question. And the answer is yes. There are other limitations on solar panels as well. So again, get with your counsel to make sure y'all are up to speed on what you can and cannot do. On your animals issue, chickens. Oh, yeah, fair housing, ESAs. We addressed it. Very good question. Any comments on short-term rentals? Enforce it. Absolutely. If your deed restrictions limit short-term rentals, it is completely and utterly 100% enforceable. The Texas Supreme Court has supported that idea repeatedly in their opinions over the past 5 years. So, yes, single-family use restrictions, residential or leasing restrictions are enforceable. However, you've got to be careful. They have to be reasonable. And if you are going to outright ban all rentals ever through an amendment to the declaration, you're running into some problems. And I don't recommend you go down that road until you get some serious legal advice. And I think that's a very bad idea. Um, Several title companies in our area that do not require a resale certificate, but only want a quote, only want a quote on what is due on the assessments. Well, look, if they're not willing to pay for the resale certificate, if an owner basically, you don't have, all you have to do is give them a statement of account and say, look, it's good for the day. I'm not gonna post date a statement of account. If you want that, you need a resale certificate. And it's title company, it's not like it's a lot of money. And title companies are taking a big risk if they do that with y'all. If you're in an area that regularly does that, because you know those resale certificates list the governing documents, and if the title company misses the governing document in their title commitment, uh, and an owner can go after them for failing to basically show all the documents affecting title to the property. Number one. Number two, what happens if there are violations on the property? The new owner is responsible for those violations because a resale certificate was not obtained. So that's very fun. I do not like hearing that you've got a few title companies that aren't doing resale certificates, because that's a really bad idea. Um, Yes, if the HOA is self-managed, the HOA can charge the resale certificate fee. Why? Because you are providing the service. What should a management company do if the board is restricting the functions of the management company to comply with Oh boy, that's a good question. Get with your counsel, let he, she, or they give a very stern warning to back up the management company. And if the management company and the council's advice are ignored, I'm look, respectfully, I'm going to look at terminating my relationship with that association, because I don't want that sort of exposure as a law firm. And the management company again, I'm not counsel for management companies, but they may have to consider doing the same thing. Again, associations, it is so important to rely on the advice of an expert in making decisions, because when you do that for single family and partly for condos, you are establishing your standard of care. And the law says this. It supports this idea that when you rely on the advice of an expert in decision making, you're going to reduce your liability potential significantly. So it's very important to listen to your management company and to your counsel. And look, if you need to get a second opinion from another attorney, that's okay. Just don't get a bunch, because then that can get you in trouble on another way. We are past our time. I'm going to try to, oh boy, they keep coming. I'm going to let's see if I can get through some of these. Director qualifications, create requirements. Single family, you cannot create director requirements other than what's provided in the statute. And there are some requirements statutorily in Chapter 209. For condominiums, there is no limit. So you can establish limits for condos. Is a resale certificate fee the same as a transfer fee? Management companies, I would say no. I think they're two distinct things. You've got to figure out what the management company does for a resale certificate fee, versus what the management company does for a transfer fee. So they're likely two distinct fees, and they two different things. Oh, GoDaddy. Thank you, Shannon Kirk. I appreciate that. GoDaddy is the website that allows you to create a website. And again, very, very inexpensive. It's easy to do. Will this be available on YouTube? Yes, it will. We're probably, I don't know if it's 30 to 60 days posting after it gets run today. Boy, oh boy. I think we're just out of time. I'm sorry. We'll try to address the rest of these questions. But hey, thank y'all so much for being here today. I hope you got a little bit out of it and learned a little bit about where we've been and where we may go with this next legislative session. And thanks. Enjoy your day, enjoy your summer, and do your best to stay out of that heat. Bye, everybody.